morning, Mr. LaChance.
Good morning. Chief Justice Marshall, may it please the court. Mark McCray is a large African-American male, essentially illiterate other than being able to write his own name. Had been tested as being borderline retarded when that word was still being used to describe people with developmental learning disabilities. His personality and his way of thinking was characterized by individuals who had tested him in the schools as being impulsive and not terribly self-reflective. He had been determined not to be able to handle his own money, his disability income that came into his possession, and so had a payee appointed for him to handle the money, to deposit the money, and to dole out an allowance for him. He was living on the streets of Boston. He was part of a small family-type unit of people who also lived on the streets of Boston. He had an alcohol problem. He had a drug problem. And this is the individual, or one of the three individuals, that was prosecuted for the murder of Helena Gardner. It is our contention that his counsel that represented him at trial provided him with ineffective assistance of counsel throughout, and that this court should, looking at the background and the information which was available, should seriously consider reducing the jury verdict from first degree to second degree murder based on his mental deficits and the manner in which the case was tried. There are a series of errors which we claim, as we had put into our brief. I'd like to start with the motion to suppress.
Is that you don't have to rank them, but is that, do you think that's the most egregious in your terms, that error, that is, that the failure to introduce any evidence whatsoever with respect to the mental capacity of your client?
Well, it's hard to pick and choose among them. I think either a close second or a first would be counsel's determination to seek the admission of Nicole Fernandez's
okay.
oral statement made to the police, which, as was described before the trial judges, counsel presented his argument for it going in, indicated that it was a very chilling and harrowing statement.
But wasn't that a strategy? I'm sorry.
No, go ahead.
Wasn't that strategic? Didn't counsel want to have him depicted to the jury as this dim-witted disciple, the fellow who's just going along with other people, and he really didn't have an active role in this process?
That would have been the case had the trial judge not limited the purpose for which the evidence could be presented. The judge restricted and instructed the jury that they could only consider that evidence for Ms. Fernandez's state of mind at the time the statement was given.
And her state of mind was that she was in entire control of this torture murder, right? So why isn't that sort of
Because he wasn't
positive evidence for him?
because he wasn't able to argue that effectively to the jury, given the judge's instructions as to what the jury could use it for.
But if it was her state of mind being, I'm in control, why couldn't you argue that?
Well, then perhaps that's another issue, because although he argued that that he was a follower of sorts, it all kind of comes together, because in addition to none of the information being presented in, for example, in the motion to suppress, which I think the motion judge found lacking, because I believe in his he did basically an oral findings, and he was careful to point out that there was no evidence introduced of Mr. McCray's capacities, and
do we have any understanding of why? I mean, the motion to suppress spoke in terms of his illiteracy, et cetera, all of the things that one would think would be the focus of this hearing.
exactly.
Is there any explanation from trial counsel as to why that route wasn't explored?
To be honest with you, I really wasn't able to speak to trial counsel. As I included in a footnote, and not for purposes of embarrassment or anything else, but trial counsel in this case, during the period of time of this trial, was under investigation and prosecution by bar counsel for some problems that he had. And I've suggested that may very well have been a factor in the amount of
Attention and focus?
yeah.
Still a chance, but forgive me. You said you hadn't been able to speak to him. There was a motion for a new trial, correct?
No, what I indicated was that, or what I intended to indicate, and I sort of got a little off track, was that after the case was over, he was disbarred
No, I understand that.
and essentially moved out of state, as far as I could.
So you couldn't subpoena him?
I was unable to locate him. And the other alternative, the other situation is that we filed a motion for a new trial with an appendix, and Judge Grabeau did not see fit to grant an evidentiary hearing on the matter, and denied it without a hearing.
And was one of the, I haven't looked at the motion, at your motion, but was one of the grounds of the motion that at the initial hearing on the motion to suppress, counsel in fact didn't call any witnesses?
Yes.
And that there was no attempt made to introduce evidence that of the incompetence of your client?
Well, I wouldn't put it in terms of competence
No, I
in
mean,
that strict sense.
No, I
But-
understand.
Yes, exactly. And as a matter of fact, the appendix to our brief here and the appendix
Yeah.
to the motion for a new trial contained psychiatric, social reports and so forth that I found in counsel's file. Now, I couldn't determine when that was found, but certainly when he found it and put it in his reports. But there is an indication, it seems to me, on the motion to suppress itself, that there was some knowledge of that kind. The one I don't understand at all is lead poisoning, which was put into the motion to suppress, but never developed, and there was absolutely nothing in counsel's file that would have reflected any contact with anybody concerning that.
One of the things that the judge had in this case, as I recall, is a video recording of the defendant's statement. How long was that? Was that an hour long?
It's an audio recording.
Oh, it wasn't a video, just an audio recording?
I think it was just an audio
Okay,
recording.
you may be right. It was a
'Cause
recording.
I don't have a videotape in my file.
Okay,
so.
well, let's say it was.
In any event, yeah, there's an audio tape of the defendant's statement to the police, and there's also a, well, it wasn't, I'm sorry, the Fernandez tape was not before the judge in the motion to suppress.
It was not. The
It was
actual, no, I'm talking about the defendant's statement
The defendant's statement was before the judge
in the motion to suppress.
in the motion to suppress, both as a recording, an oral indication of what he was saying, and also a transcript. And there was a transcript made of the oral tape.
What I'm getting at is the judge could listen to this conversation that went on between the defendant and the police, presumably over a fair amount of time, and based on that could make some sense of whether this person was understanding what was being said, responding appropriately, things of that sort.
In Mr. McCray's case, I think that is somewhat deceptive, and I say that for this reason. Mr. McCray, despite learning disabilities and so forth, likes to use big words. He likes to portray himself as somebody who is smarter than he is. So you would not necessarily, even over a short period of time where he's answering the questions of the police and is telling a story, get from him a true indication of his capacities and his capabilities. He also, and I think this is reflected in a number of the reports, he likes to be the nice guy. He likes to cooperate with people. He likes to appear to be everybody's friend.
Mr. LaChance, how many times did Mr. McCray sign the Miranda card?
Well, I know he signed them once, but
Just
I don't.
once? Well,
Oh, you mean over the course of his life?
no, I'm talking about around this statement. Well, actually, he gave two statements to the police, didn't he?
Well,
The
there-
first one, he denied any knowledge of anything. They gave him his Miranda rights.
And that wasn't taped, as far as I can recall.
Then the second one, they did the follow-up.
So
and-
there was, something occurred between the first and the second.
Yeah.
Then they turned on the machine, then they taped it. Then they turned off the machine again, and Mr. McCray initiated some additional conversation in which, having already given whatever he gave, he was trying to clarify a couple of things he said earlier, so they turned it back on. I don't recall whether they gave him the warnings again when they turned the machine back on, or whether they just reminded him of them. I think there's no question that he got the Miranda warnings. The question is, what was his capacity to understand, resist the questioning, given his personality, and given his mental condition and his mental intelligence? And the answer is essentially the judge didn't hear any of that. And the judge made a big point in his ruling of saying, I've heard the testimony of the police officer, and I've heard the statement that was made, and I haven't heard basically anything else with respect to Mr. McCray.
And what was counsel's response to that? What was counsel's response to that?
Well, I don't believe there really was a response, considering the fact that what he was doing is essentially dictating to the court reporter his findings. And that was at the very end of his findings.
That was his decision.
His decision. Then, basically, denying the motion and setting forth the reasons. I don't know whether a reasonable counsel, would jump up in the middle of a judge making a decision.
I understand that.
Yeah.
Mr. LaChance, is there any indication that counsel obtained an expert to evaluate Mr. McCray before the motion to suppress?
I do not believe so. There was, after the motion to suppress was heard, there was a psychologist, psychiatrist.
That was almost a year later, wasn't it?
Yes, it was.
Could I ask you a question?
Sure.
Oh, I'm sorry. You wanted to finish. I didn't mean to interrupt you.
Oh, I'm all done.
Okay. The question I wanted to ask you was about the Fernandez statement, and I know I'm being obtuse, and you may have addressed this, but you say the judge, the problem was that the judge limited it to Ms. Fernandez's state of mind. Mr. McCray, this wasn't a joint trial, but how else would it come in as a statement of a co-conspirator? I mean,
It's not admissible. What happened was they went for the motions in limine.
Oh, so when you say, but it got limited, you wouldn't have, you saying the whole problem was it came in at all?
Oh, absolutely. Because what happened was defense counsel told the judge he was going to offer this tape. The judge heard him out. The prosecutor said, we object initially, and then when the judge said he was inclined to let it in, the prosecutor said, well, if you're going to let it in, we want to put it in our case in chief so we don't look like we're hiding something from anybody. So that eventually was agreed upon, but the judge announced that the only way it can come in is for her state of mind. It can't come in for the truth of what she says.
That was a correct ruling, though. It was a correct ruling.
Sure. We don't challenge the ruling.
You're just
We
saying
challenge
on the balance, it was an unfortunate motion to admit. But you have to admit
Well, I
that
think
there were benefits. The statement really, as best I can tell, was suggested, as was consistent with the defendant's view, that he was under the control of this woman who was just evil incarnate and viewed herself as that during this torture murder. I mean, again, how can, there may be some bad things in there that it would have been nice if were excluded, but on balance, this was a tough case, and this was a horrible crime, and the defendant was there and participated, and isn't this the only edge that could be gotten, and therefore not manifestly unreasonable?
Well, I think it is manifestly unreasonable, and I think it's manifestly unreasonable for the reason that the trial judge gave an instruction before the tape was played, my recollection, and during his instructions to the jury.
Did counsel know in advance that the judge was going to give that limiting instruction?
Absolutely, told him before trial.
Okay. So you're saying then that with the knowledge that instruction was going to be given, there was no he lost his tactical advantage as to the contents of that statement.
Assuming that the jury would follow the judge's instruction, which this court repeatedly confirms that juries follow the instruction of the judge, then it was all downside and almost no upside to playing that, especially with statements about urinating or throwing a cup of urine or so forth on the deceased. And that's a pretty tough fact, and that's a pretty tough thing or image for a jury to have.
Of course, that was limited to the state of mind of the declarant as well.
Yeah,
But this is a tough statement, but there is some benefit in there that could be exploited in a very difficult case.
Well, the problem with that is that there was also some information on the defendant's tape of his statement relating to that specific
Right.
happening, although it describes it in a very different way. So I notice my time is up. If there aren't any other questions from the panel, I'll leave it at that. I'll just say that I think fundamentally, given the way this thing played out, Mr. McCray didn't have a fair trial, and that 2 seconds, gather my thought here, and that given the status of his participation in this event, it's a far more appropriate, a second degree is a far more appropriate sentence, because there is such a huge distinction between Ms. Fernandez's culpability and his own. So, thank you very much.
Thank you, counsel.
Thank you, Mr. Luchins. Good morning, Mr. Curtin.
Good morning, Chief Justice Marshall. On behalf of the Commonwealth, Kevin Curtin, Assistant District Attorney for Middlesex, and with me is Kimberly Chin, Boston College Law School student who is on the brief. I'd like to start with the admission of the Fernandez confession, because that may well be the defendant's strongest argument.
How did defense counsel argue Fernandez's statement to the jury?
Well, he argued that it showed that he was a follower, that he was a schlep, that he was burdened by his low intelligence and lack of education, and that he was in the company of evil people who were more powerful than him, smarter than him, and that he did not therefore share the intent. And he focused on the statements that Ms. Fernandez made, that he said, not to do it. She made and statements that the defendant himself said, told the police that he didn't want to do anything more. He thought it was just an assault and battery. He asked them to stop.
So it's your position that even as limited, the statement still had value to the defendant?
Yes, because it showed her state of mind. It showed the mind of a killer, a cold-blooded killer. It showed that in a chilling and graphic way.
Of Fernandez.
Ms. Fernandez, and details of the way in which
we've done that case.
it was carried out were therefore brought forward, and to the defendant's benefit, I submit. And it did significantly downplay Mr. McCray's involvement. If you look, for instance, I just draw the court's attention to a couple of passages in the supplemental record appendix on 97 to 98, where the defendant is asked, when you Ms. Fernandez, killed Helena, did Randy or MC help at all? Answer, no. MC told me, you can't kill her, you can't. Later on, at page 104 in the white appendix, MC didn't want me to do it. They both asked me to stop. And then the threat, her state of mind as being in control, the threat, I will commit another murder to cover this one because I don't want to spend the rest of my life in jail. She's saying these things. She's for a reason. She had said that she would cover. She told Jerry Johnson that she was prepared to cover for her friends, her family.
Were there any, I don't want to say unusual, but were the usual instructions given?
Yes, they were.
So regardless of what she said, if you have the facts of his staying, being there, I take it there was no, I mean, he never said, I left, I told her not to do it, but I left.
That's right.
But if the jury, notwithstanding what they may want to conclude about McCray being a follower or sort of under the influence, that's not going to overcome. If the jury followed the instructions of the judge, and the judge presumably said, if you're there, and so on and so forth, I mean, they're almost compelled to conclude first degree, aren't they?
Well, it gave them an opportunity to
To do what?
To consider whether he really, his will really was overborne by this more powerful person, because the evidence, and you can take a look at the evidence readily to see what it would have looked like without this confession.
Right?
And you can see, based on what he told Jerry Johnson, he admitted to hitting her, to beating her while she was bound. He admitted that he urinated on her in a particularly awful way. He admitted, excuse me, that he participated in and discussed whether she should be killed or not. You know,
So what you're saying is not, may not have been helpful, but useless without that.
I think it probably was, in a tough case, perhaps the only straw. It definitely substantially advanced his theory of the case, that he was a weak man of low intelligence who was subject to control and did not share the intent to commit murder.
Now, here's the monster, and listen to her. You can listen to her state of mind. This is
Just
the
listen
monster.
to her. How chilling.
But what about the adequacy of the defense with respect to the defendant's mental competence? I don't mean in the legal sense mental competence, but I mean in terms of his being mentally challenged.
How was that presented at the trial or in the
Yeah.
motion to suppress?
No, the motion to, can we start at the motion to suppress?
Well, okay, all right.
Well, in the motion to suppress, it wasn't presented by the defendant at all. And to answer the question that came up earlier, why? The report that was admitted in trial with Dr. Cohen, that wasn't written until 3 months after the hearing on the motion to
But what's the
suppress.
basis of a motion to suppress if you haven't done your preliminary work?
Well, the defendant made a substantially incriminating statement. He had Miranda rights.
No, I understand. So
he
the only
was required-
basis on which you can do it is to say it's not voluntary.
Or that he did not validly waive Miranda.
Well, I
Right,
mean,
but that all goes
but
to
that's
the mental capacity issue.
That's right. What I'm saying is that there really wasn't evidence. The only evidence that there would have been those 1978 and 1980 reports. And even though those were not admitted in the motion to suppress, there was a motion for new trial, and the motion judge was able to consider those in the motion for new trial and concluded quite properly that they were not really relevant to show the state of mind at the time of the confession. It wouldn't have helped the defendant to have those reports.
But he could have had an expert examine him before the motion to suppress.
That's right. He could have asked. He could have sought a continuance if it was late being done. That's true. He could have sought a hearing if it was really that helpful for him. But this question of voluntariness, as he conceded at trial on Volume 4, page 7, really wasn't a live issue. The voluntariness of these statements. It just wasn't much evidence that these statements were coerced.
No,
the
not
way the police
coerced.
officers.
I think the issue is not that the police were coercing him, but that he didn't have the capacity to waive Miranda or to decide whether he should speak or shouldn't speak.
Well, the record really is overwhelmingly against the defendant there.
well, maybe now you go to Justice Spina's question, which was what was the evidence at trial?
And the evidence at trial, with respect to the motion to suppress, nothing that came in at trial would have helped him. And the motion for new trial, and the motion judge rejected the evidence in its entirety, even though some of it was not at that point available. And the reason is because the police really conducted a very fair interrogation. It's true that a portion of it was not recorded. It's true that the defendant gave statements before the tape recorder came on, but this was before it was clear that that was permissible.
But what about apart from that, though, what about the notion that the defendant was not, he was a follower? I mean, wouldn't it have been extremely helpful to the defense in this case to have had expert testimony that, this person was mentally challenged and easily led into doing things?
He did at trial. He had the best that he could do with the evidence that he had. The problem was that the defense psychiatrist, Dr. Cohen, said that there was no evidence that he was either insane or not criminally responsible. He had to acknowledge that if it were true that the defendant had punched the victim while she was bound and about to be murdered, or even not bound in the trailer, that if it was goal-directed. There was no evidence that he was suffering from a mental disease or defect. It was not going to get him a not guilty.
A diminished capacity.
That was the issue on which it was argued. It was argued that he didn't share the intent, he didn't have the capacity to premeditate, based on and the process. And the defense attorney argued that very vigorously. It's argued in this case that the defense was abandoned. The theory of his lack of mental capacity or his diminished mental capacity was abandoned in closing argument. The problem is there wasn't really much evidence of it. There was evidence of low IQ in a test where he has to read it, but he's illiterate. You give him the IQ test where it's read to him and the IQ is much higher. And this court in Ostrander has pointed out that just being illiterate or just having a low IQ, that's only one factor. And so the defendant developed this theory of low capacity throughout the entire trial. He opened on it. The defendant's dopey way is the way he expressed it. His childishness, it was way that it was previewed for the jury. During the cross-examination of Jerry Johnson, it was brought out. He tried to bring out whether the defendant, lacked mental capacity with Jerry Johnson. Jerry Johnson, however, knew him well, and had to acknowledge that he's no dummy, and that is in accord with the other evidence in the case, that he was functioning very well and quite shrewd in many respects, although he was a man of low education, of little education. He was mildly mentally retarded at best, and not the ringleader. And that was what the defendant had. And so that's what he closed on. And he did a pretty good job. If you look at his closing, and this is in the red brief on page 54, I've excerpted a substantial part of it, and you can see there's no disavowal of this defense of low mental capacity. He asked the jury to consider that mental state, and he powerfully integrated what he had argued in opening statement, the evidence that he could develop during the trial, in this portion of his closing. I put on Dr. Cohen yesterday. He had seen Mr. McCray, and there's not a great deal of significance to that testimony, except, this is what the defendant says is disavowal, except that I put him on because I wanted to have some objective viewpoints on what his intelligence were. And the government attacks that. The testing has all been, all of the evidence, he's focusing on all the evidence, that he is a borderline retarded person. He doesn't. He's had problems throughout his life. He can't read. He can't write. He had to receive money through a payee and a trustee, Social Security disability. He's not a highly functional individual, despite Dr. Annunziata's viewpoint that he's functioning well within the context of a homeless person. Does that make a lot of sense as defense counsel? And all of the relevant evidence, defense counsel argues, shows that he was mildly retarded and a follower, a person who went along with strong individuals. Remember, I talked to the doctor who examined him back in 1980, Hamilton, and now he's a person who would follow along with the stronger individuals, easily led, doesn't think for himself, not able to think for himself. He was a schlep, and he fell in with evil incarnate itself, Randy Williams and Nicole Fernandez. Now, that's pretty good. That's about as good as you're going to do in a case like this.
This is off that, but I should have asked Mr. LaChance, but in the motion for new trial, and I understand there was no hearing on it, but was there any examination or the challenge to the motion to suppress presented in the motion for new trial, was it based on the mental capacity evidence that had been admitted at trial, or was there a new? There was nothing. There was no affidavit or something from a different doctor who had since then examined him or anything.
No, that's all that there was. There were some reports that were referenced in Dr. Cohen's reports, but they were from 1978 and 1980, and they weren't that helpful.
Mr. Curtin, I haven't read the whole of the closing argument. How many times did defense counsel say this man did not have the intent to murder?
Well, I didn't make a note of that, Your Honor. I'm sorry, but that
Can
was
you just remember off your top of your head if he ever said, he didn't have the intent to murder?
Yeah, I think, I wish I could. I wish I could, but that was the thrust of it.
No, I understand it's the thrust of it.
It was about the intent. It was about whether he really was his will, the intentional killing.
Yeah, but to say that somebody's a schlep and he fell in with evil doesn't tell me that he could never have had the intent. He didn't have the intent. I mean, it's...
I think that's such a wonderful way to argue it, that word schlep. That's
Did
a wonderful word in this case, you know.
Defense counsel asked the jury to return a verdict of second degree? Or,
He did. He asked, he said that he did not, that he should not be found guilty. He argued that,
of
you know,
anything?
he argued substantially second degree, is my memory of it. The thrust of it was that. The thrust really was that he didn't share the intent, that he was a follower, that he
I
was
don't
not so much
understand that. I
arguing,
just,
he
you know,
wasn't so much
sometimes
asking
we're,
for a verdict, as I recall.
you know, you've got very clear jury instructions, and then you've got what what a very familiar defense, criminal counsel sounds like.
Yeah, so the question may be, what was the jury instruction on the issue of intent?
I mean, we'll look at the closing argument, obviously, but
Well, the judge did provide accurate instructions on deliberate premeditation
Sure.
and on malice. He provided instructions on humane practice with respect to the statements that were that the defendant gave to his friend and to police.
let me put it this way. It strikes me that the piece of the argument that you've just read is absolutely consistent with the third prong of malice, right?
Well, perhaps it could, because if his participation was limited to only beating her up, then he would not have shared that intent. And now, with respect to the
So what you would
question
be
of
looking
whether he asked for a specific verdict, and I'm sorry that I wasn't able to
That's
answer
when
that
you're
question.
trying to help the jury. You're saying you're going to hear instructions on this, because he probably can't. I mean, the judge is going to give those instructions.
Right.
You know, and so what you're trying to do in a closing argument to say, don't go there, go here. Or don't go there.
That's
if you're
right.
going to go anywhere, go here.
Go to the point where he didn't participate. He didn't share the intent under the law. That was the language that he focused on. He didn't focus on the legal language.
Okay.
He focused on, he did not share the intent he didn't in fact participate, and he understood that the jury was going to be charged, that he had to share the intent under the joint venture instruction that was given. That's the way that that's the best that I can do with it at the moment on that. But the way that he summed up makes it very clear that the theory of the case was that he did not participate. He said, stop, stop, stop. That was the theory on which he could get, not guilty on the charge of first-degree murder. There were lesser charges. There's assault and battery on which he would have had to share the intent. There were 4 counts of assault and battery. There was a kidnapping. He was in trouble on that because he participated in the kidnapping to a significant extent. He left after he had planned it out. He was wearing gloves.
Was a
in the
joint
trailer.
venture instruction here?
I'm sorry?
There was a joint venture instruction
Yes,
here?
on all of them. Yes.
A good, straightforward joint venture instruction that would make clear that you don't actually have to participate in the killing?
Yes, you have to. It was the 2 prongs that were being expressed at that time were correctly expressed, focusing on that he acted to achieve the end that was intended, and that was shared.
Share the intent.
Did the judge place any emphasis at all in his instructions on the theory of the defense, and that the jury, one of the questions in the case was the defendant's mental state, his requisite mental.
Yes, he did. The judge specifically gave humane practice on the issue of intoxication. He gave it at defense counsel's request after his general instructions. The defendant had more than adequate instructions from which the jury could infer that he was indeed a follower, that he didn't share the intent, that he was dim-witted, that he was under the sway of a more powerful person. That was the thrust of the defense on the first-degree charge, and that was a pretty good defense. It was vigorously advanced by counsel who appeared to be quite well prepared. He provided jury instructions that appropriately asked for the type of instructions that the judge ultimately gave and that he was entitled to. The problem was the evidence. That was the problem. And, you know, with respect to the issue of whether he could have suppressed the statements that were so terribly damaging that he gave to Jerry Johnson, you know, there was no way to do that, because the only way he was going to get that was if they were involuntary. He knew Jerry Johnson for 3 to 4 months. They were friends. They socialized almost daily. There was no coercion on the part of Jerry Johnson that could lead to some suppression of those statements. Counsel asked in advance. He asked for voir dire. He asked for limiting instructions. The judge asked him later on, please remind me if we're really going to do a voir dire. He never did remind him to do a voir dire, but with respect to whether the statements to Johnson were voluntary or not, but that was because there really wasn't evidence that those statements were involuntary. Trial counsel had a strategy, had a plan. The plan was that the defendant was a weak individual under the sway of strong people, and he did not participate in the first-degree murder. He did not share that intent. That was the argument that was advanced. That was the best argument for the defendant, and that required, I would suggest, the admission of the Fernandez statement. It was not manifestly unreasonable to admit that statement because it substantially supported the defendant's theory, and may very well have been the best evidence of that because of its graphic nature.
Mr. Curtin, as you know, we take a look at the entire record. I understand from Mr. LaChance that he has a copy of the defendant's confession in his file. Is that part of the? Was that introduced at trial?
Yes, Your Honor.
So it's a marked exhibit?
Yes, the confession of Fernandez was exhibit 20.
No, of LaChance. I mean,
Of
of
the yes, it
McCray.
was. Yes,
The confession of Fernandez came in as a documentary exhibit?
it did. Exhibit 37, and it was played. The tape was played. It was played. That's what the defendant wanted. He argued for it. The prosecutor asked that it not be admitted.
Thank you, Mr. Curtin.
SJC-18696, Commonwealth versus